Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
Our guest today is Christine Matus. She's an estate planning attorney in Toms River, New Jersey. Christine, how you doing?
I'm doing great. Thank you, Steve. I'm excited to be on this show.
Oh, well, great. Hey, tell me a little bit about yourself and your firm, Chris.
Okay. So I am, first and foremost, I'm a mom. I have two beautiful kids. I've been married, for for a while now. And we have two great children. And my youngest was born with Down syndrome. So because of that, I've dedicated a large portion of my practice to helping special needs parents, helping them navigate through estate planning, and even in special education law, we've added that component. I like helping people. We are here to do what we can to be that hub for families. So we're not your typical attorneys that you might think of. We're practically, we'd love to think of ourselves as part of our family members, to the clients that come across us and have honored us to see what we could do to help them. But yes, a lot of our focus is helping families with their estate planning, but especially those with special needs members.
Okay, so tell me, what is estate planning? And this is a two-part question. What is estate planning? What does it include? That's the first part. And then talk about how you work with special needs families as it relates to estate planning.
Well, I always like to think that, that great saying, I think it was Benjamin Franklin saying, failing to plan is planning to fail. Estate planning, in a nutshell, is about planning for the unknown or for the future, and at least trying to contain the chaos of what will happen when you're not around or your loved ones are around, left when you're not. Estate planning usually consists of probably the three most popular things, which are a last will and testament, a power of attorney, and advanced directive living will. Those are three things that we really feel are the cornerstone of everyone's estate plan. An estate is anything you own, and that could be assets and also debts. Not many people want to talk about that aspect. But when you pass away, it's nice to know that you have a plan how everything should be taken care of, and not just left to chance or some roll of the dice where we tell our family members, well, you'll figure it out. But it's nice that we have it planned out, because maybe there are things that we could do with our assets that we could help someone, help an organization. And also, if there are debts that are involved with our estate, that we already had a plan how that's going to be taken care of, so no one has to worry about what they should do. And that's what we do. We like to help people plan their future, plan for the next generation. And with estate planning, when you have someone with special needs, well, it's even more important, Steve, because we do have to add that other layer of who will actually take care of our loved ones who may not be able to make decisions for themselves, who may not be able to manage things for themselves. My husband and I, we have a special needs trust, and in it, we were able to decide who's going to take care of our girls, who's going to manage funds, who's going to raise them, and how will they be raised according to how we like it. There's things that can be done where we can actually give an idea of the certain quality of life we expect of our children, what kind of upbringing we'd like them to have, what religion and education we have planned for them. It's a lot of work. I won't try to candy coat that, but at least once you start rolling and start putting things into place, momentum will take you away. The hard part is lifting up that phone or sending an email to a firm like ourselves and letting us know that, we really would like help in this. But it's something that we do on a regular basis. So there's an organization to it. We're not going to be going back and forth and saying, yeah, what would we want to do? We have pretty specific questions on how you can deal with things. And we've been doing it for a while now. So We know what certain scenarios would come about, and we like asking clients what's their number one goal, because all of these, it won't work unless we meet what you have your dreams are for your family, what you think you want for your kids or for your charities that you're very heavily involved in. It starts with that. What are your goals? What are your dreams?
Okay, now you use some terms there that maybe we should review: will, probate, power of attorney, and trust. Let's start with a will. What's that?
Sure. Well, a will is probably one of the most popular documents that people hear about that they should need when they die. And the will is, it's a legal document. And in it, you're going to be nominating certain people to be in charge of your wishes. You get to tell who will receive your assets when you're no longer around. And you also get to do some other things too, that say there are people in your life or organizations that you would like to have a certain portion of your estate, your assets. You can name them. And also, if there's people in your life that you really want to make sure they don't have a say in your assets, that's also equally important. You can name certain people that you want to make sure it's clear that they're not involved in your assets and your estate, because a lot of times, well, we have very complicated lives. And the clearer we spell out how we want things to lay out, how we want our legacy, the better it is for everyone. So a last will and testament is a document that takes effect when you die, and it gives you a roadmap to your loved ones. Well, this is where I have things, and this is where it's going to go. You can also use these documents to help you with important decisions about taxes, about guardians for minor children. I've always said, Steve, that, a lot of times people will say, well, I don't know if I need a will, Chris, because I don't have anything, meaning that they think that they should have assets of a significant value, but it's not true. One of the most important things a will can do is that it nominates someone to take care of your minor children. If you have young kids, regardless of your assets, that's probably one of the most important things you can do for your family, is making sure you have a will and that you nominate a guardian for them, someone who's going to step in and raise them the way you want them to be raised. And I have to say, that's really one of the motivations we have with a lot of our clients who come in and want a will done. It's because they have young children and they realize, if we're not around, who's going to take care of them? And by having it on paper, it'll be such a good, smooth affair that will be just, as it'll be a difficult time, but making a difficult time less stressful and less complicated by having it in writing. So that's probably one of the most important reasons why I advocate for having a last will and testament, or something in writing that indicates your wishes for your children. Power of attorney is another document we feel is so important, because it's a document that takes effect, Steve, while you're alive, but you probably may not be able to make your own decisions, or perhaps you're just not available to make legal decisions. And so you're nominating someone to step into your place. A lot of times, if you're married, husband and wife, they're power of attorneys for each other, meaning they're legally authorized to talk on each other's behalf, sign papers on their behalf. It's always interesting to me when we have some documents in our office and we need the both signatures of spouses, and say one spouse is available and the other spouse is either working or on a trip. And they'll say, well, that's okay, Chris, we're married. I'll sign for her, or I'll sign for him. And we always have to ask, well, do you have power of attorney? And like, well, why? Because we're married. And no, that's not good enough. Just because you're married, you need to still have a legal document that gives you authorization to sign on behalf of another individual. And it's important. But another aspect is that, God forbid, you're starting to lose your faculties, you're unable to make decisions, or you just can't handle certain things on your own. A power of attorney is a very powerful document where you've nominated someone who can go to the bank for you, who can pick up mail for you, who can open and close accounts for you and write checks for you. We had a case several years ago where it was a young couple and they had just gotten married. And unfortunately, the husband fell into a state where he couldn't make any more decisions. And the rent was due. And wife started to write checks, and it was rejected by the bank because they said, you're not an authorized person on this account. For some reason, they only had one bank account at the time. And so she had to pay the rent, she had to pay utilities, and all of the checks were not recognized. So what ended up is that we had to make an application for guardianship. A guardianship is a court-appointed order that allows someone to be the agent who can be a legal representative. It's a very elaborate, complicated process. It does take time, and it costs thousands of dollars, whereas a power of attorney does not. It's a very quick document. It costs a couple of $100 and can be done very quickly. So again, we really try to encourage people to have a power of attorney. And the last document that you should have, at the very least, is called an advance directive living will. It works the same way, Steve, as a power of attorney, but it mostly takes place for nominating a person to make decisions for you in the medical field, in your healthcare decisions. You've also made some decisions on your own if you became terminal and you can't communicate what you want. There's been lots of cases in the news about people who may not have this living will document. And unfortunately, then what happens is that the family is in conflict. One half of the family says that they would like them to keep going with life support in whatever means necessary. And then there's another factor of families who feel that no, this is not what they would want. They may have mentioned it verbally too in the past that they don't want a life like this, and we would like to terminate life support or whatever means. But what happens is that when there's a clash like this and there's no document to support one way or the other of your wishes, it has to go to court. And that is a long ordeal that costs a lot of money and a lot of stress. So this advance directive living will is something that we highly recommend to families that you have, because again, it takes off the pressure for a family member to make decisions, and it gives you time to think about really what you would like to happen if you can't make decisions and how you would like to be treated medically and health-wise. So it's important. So that to me is your cornerstone of what an estate plan should be. There's other things you can have, Steve. People talk about trusts and something elaborate, and it really has to fit with their goals. If they tell me of a certain goal that they have in mind, that maybe a last will may not fit and that a trust is better, we'd help them with that, and vice versa. Sometimes families have an idea what a trust should do, and we say that, you know what, you can do just as well with a last will and testament. So it really is focusing on the goal of the family.
Now, one last question I got. What is probate? Can you avoid that if you have a will, or how does that work?
Right. So probate is a process, Steve, is that once a person dies, we would have to find out, well, what are their wishes? And to do the official documentation of what their wishes are, if you have a last will and testament, you would go to your local surrogate court and you would bring a copy of the will. And at that point, that is during the process of probate, where they authenticate the will. They make sure it was a valid will done properly. And now that we find out who is the official representative of the estate, that would be the executor. And so probate will help establish that. In certain states, it's very complicated, Steve. But in New Jersey, 99% of the time, probate is not complicated. Probate is not expensive and can be done quickly. And that's a good thing about New Jersey. And if you want to avoid probate, I usually want to find out why, because like I said, probate in New Jersey is really not as complicated as in other states. But if you have a trust, it does avoid probate, and I guess we need to go back and decide, well, and define what is a trust. And a trust basically to me is a box. And I can do a lot of things with that box. I can create a box to save you taxes. I can create a box to protect your special needs son or daughter. I can create a box to protect assets if you think you might be needing long-term care like a nursing home. And if we do create this box, one of the benefits is that it does avoid probate. And there are some people who say, yeah, no matter how easy you tell me it could be, Chris, I want to avoid it. Okay. The other thing too with a trust, Steve, is that it's private. It doesn't become public. Once someone dies and we have to probate a will, that will becomes a private document where everyone can read it. It's filed. But if anyone were to go down to the local county court and say, I saw John Smith on the obituary, did he have a will? And you can get a copy of it. You pay a nominal fee and you can take a look at everything he had. And there are some people who have very sensitive, very private things that they want to discuss. And if that is the reason, then we highly recommend a certain trust, because then we know for sure it's not going to be public. They won't know the details of their estate. So that is one way. But if you have a last will and testament, you will not avoid probate. That needs to be performed. But with a trust, you will avoid probate.
Now, realizing that you specialize in working with special needs families as it relates to estate planning, Chris, what's the most common question you get?
Well, it's interesting. The most common question we have with the trust planning with special needs people is, if I'm not around, Chris, and we don't have another family member that we trust, who will step in for our loved ones? And I have to say that is one of the most difficult questions to deal with. Most times we want that family member. We want someone who's familiar to step in as a trustee because it gives comfort to you as the person who creates the trust and comfort to the person we're helping. But oftentimes we've also told families that if we can get a professional trustee, if there are funds and assets available that could accommodate that, it is ideal because there's paperwork involved when you are a trustee, paperwork to file, and there are requirements and rules about how we distribute money to our loved ones. So oftentimes, Steve, we've recommended that if you have a loved one, we see that we want to make sure they have the adequate resources available to handle this type of money issue. Perhaps we would introduce them to financial advisors or institutions that could work with them. They don't have to take the place of managing everything 100% for their loved one, but at least come in as an advisor to them. And a lot of times that's very helpful. It gives them mind at ease. But if they don't have a loved one, then we do have to look into some professionals who can step in and manage the funds. And there's also other resources available, such as what they call a pooled trust, where the trusts are managed, several trusts are managed by one organization, usually a nonprofit, who can help out the families. And it has to fit. But that is one of the most popular questions. If we don't have any other family members that we know or feel confident who can follow through, who can we go to? Thankfully, there are options, but it really has to fit the family. And that does take time to discuss and go over because it is very nerve-wracking. And it can be upsetting if we feel we don't have any answers. But thankfully, we have had experience in that. We have several options that we can discuss with the family members because that should not be a reason not to do this, not to take care of your loved ones.
Good information to know. Our guest today is Christine Matus. She's an estate planning attorney in Toms River, New Jersey, and she specializes in helping families with special needs, with kids with special needs. Chris, how can you be reached?
Oh, we can reach several ways. We're located in two places. We have an office in Toms River, New Jersey, and in Red Bank, New Jersey. Our phone number is 732-281-0060. Or you can also email us at admin, that's ADMIN, at matuslaw.com. That's MATUSLAW.com. Or you can go to our website, www.matuslaw.com. And in there, you can click on the link to send us a message, and we would be happy to see what we can do to help you and answer some questions and give you, at least point you in the right direction and provide you some helpful information. Our website is pretty user-friendly, Steve, and we even have a complimentary ebook that goes a long way to explaining a lot of things that we spoke about earlier.
Hey, Chris, thanks for being on the show. Good stuff to keep in mind here.
Oh, thank you, Steve. I really had a good time, and I appreciate you having me on this show.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.